Coming to you live from Radio Cayman Studio.
For the record.
For the record. Hear from your government officials, independents, and the opposition on issues that matter to you. The record. Engage in an open dialogue between residents and lawmakers.
For the record.
The record. Informative, impartial, insightful.
This is your talk show.
1-800-534-8255. Your calls, your input. This is For the Record. And now, your host, Art Connor.
Good morning and welcome to For the Record. Today is Monday, the 22nd of February, 2016. I hope and trust that you had a great weekend, enjoyable weekend. We had no rain, lots of sunshine, and the temperature seems to have gone up quite a bit. Those drops in temperatures that we had in the past weeks was really refreshing, as well for us. I also want to point out to you this morning, those of you who may have been on the road early this morning may have experienced some delays. I'm not sure what the delay was all about, but there was a lot of traffic backup from about 6:45, maybe even 20 minutes to 7 this morning. And no doubt some of you may have been delayed getting to your places of work as a result of that. Of course, I want to thank you for allowing For the Record into your homes, into your places of work, whether it be an office cubicle or if you're working on the outdoors, and also into your vehicles as you traverse the roads of the Cayman Islands. Of course, For the Record is a show produced by the staff and the management of Radio Cayman, and it is geared towards keeping you abreast of issues as they arise and play out on the local, regional, and international scene. I have the pleasure of being your host. My name is Art Connor, and you're welcome to join me every Monday, Wednesday, and Friday from 7:30 a.m. until 9:30 a.m. Our phone lines are always open. There is always someone there waiting to take your calls, normally in the beautiful voice of Miss Susan Watson. You can call us on our toll-free number provided courtesy of Flo. That toll-free number is 1-800-534-8255. You can also call us on 949-8037 and the 949-6990. And of course, if you don't like to talk on the telephone, you can email us at For the Record. That is one word, For the Record, at candw.ky. And of course, For the Record would not be possible without the support of our proud sponsors. And today, For the Record is brought to you by Caribbean Alliance Insurance Company Limited. Their motto, Tomorrow Secure. You can call them at 949-9744 or visit them at Alista Towers. So again, welcome to For the Record, and we will have an interesting and exciting show again for you this morning on For the Record. We're happy to welcome into the studio with us this morning Mr. Peter Goff, who is the strategic advisor to the Deputy Governor. We're expected to have other guests in the studio as well, and no doubt they probably have been delayed by the delay that I spoke about this morning, the traffic delay that I spoke about this morning. We're expecting to have Ms. Deborah Prendergast with us. She's the administrator to the Conditional Release Board, and we also expect to have Mr. Neil Lavis, who is the director of prisons, with us as well. So until they reach Peter, it's going to be a face-to-face between you and me. So I want to say to you, good morning and welcome to For the Record. I believe this is your first time on For the Record as well.
Yes, it is. Good morning, Mr. Connor.
Good morning. I think we can jump right into the topic that we're going to talk about, and this will give you an opportunity to give our listening audience some background information on the conditional release law in terms of its drafting, the reason for its drafting, passage in the Legislative Assembly, and when it actually came into effect.
Yes. First of all, I'd like to start by saying that what problems are we trying to address with this new law and regulations? Well, when it was last measured, the reoffending rate in the Cayman Islands was 73%, which is higher than our Caribbean neighbours, which runs at 60%. The other statistic, which is quite worrying, is the fact that the average world prison population is estimated at 168 prisoners per 100,000 population. Our prison population is nearly double that. So if we gross the population up, it means that we are looking at the moment at 346 prisoners per 100,000 population, which, as I say, is double the average world prison population. Back in 2010, there was a spate of murders. The National Security Council and the government decided they wanted to develop a strategy to reduce crime. The government decided that there's a number of strategies to actually reduce crime. The early intervention, trying to identify the risk factors in young people, and that's currently being undertaken by the Ministry of Education. The second strategy was to look at ways of what we call situational prevention, which was looking at planning requirements, security features, environment, lighting, and neighbourhood watch schemes, those things which can reduce crime. The third one was obviously enforcement and a speedy criminal justice system. But the one that this conditional release law and regulations is focusing on is to reduce reoffending. So the objective of this new law and regulations is to reduce the size of the prison population and to reduce reoffending. This is not going to happen overnight. It's going to take some time, maybe 2 to 3 to 4 years. We'll start seeing the effects of this new law. The new law and regulations has been a long time in the making. I'd like to maybe mention an early advocate of this new law was Dr. Philip Pedley, who had a passion for prison reform. And I took up the cudgel when he died. So I just wanted to mention that, Mr. Connor.
Certainly, yes. No, that is quite a tribute to Dr. Pedley.
Yeah.
Pedley.
Now, the first question, obviously, is, well, what's the difference between the old system and the new system? What is the difference? Well, the new system focuses on rehabilitation and risk, not passage of time. It focuses also on the victims and how the victims can be involved in the process. It also talks about how we deal with people that are incarcerated for life with no tariff. At the moment, or prior to this law, should I say, because the law was passed on back in 2014, and the regulations were passed by Cabinet on February the 15th.
Yes.
Yeah. Before this new law and regulations, there was a section of the prison law that dealt with it. And we were advised by a number of people that it needed a law. We got legal advice from Dr. Lloyd Barnett, who was a QC from Jamaica, renowned QC, who advised us that we needed to have legislation to underpin the parole process. And at that time, the Human Rights Committee, that's back in 2007, started to talk about life prisoners with no tariff being inhumane. So these things have focused us on this new law and regulations. The major differences at the moment, or prior to this new law, the governor made all the decisions. Mm-hmm. She made the decisions on whether a person should be released or not, whether the person should be on a license, and what license conditions that prisoner should be on. Under the new system, there will be a board, an independent board, and they will make all the decisions on whether to release, what conditions, whether to revoke the license if the license is being compromised.
So the decision is there. It's not advising the governor to make a decision.
Exactly.
It's the board's decision exclusively.
Exactly. So it's truly independent of government, as it is in all countries. The parole board is not has any political influence. It's truly independent. And we've just appointed a new 9-member board. and there was an open recruitment process for the new board. I think that's the first time that's ever happened. And we had over 20 applicants for the new board. Of the 9 members, the law specifies we should have certain specialists on the board. And we were very fortunate to recruit an ex-magistrate as the chairman of the board, a Queen's Counsel as the vice chairman of the board. We were able to recruit some lawyers. We were able to recruit a psychologist, and we were able to recruit a pastor. So we have a very balanced, well-experienced board. But they will rely on professional advice. The persons that will be advising the board will be the probation officers, which will do all the reports, home background checks and all those things. We will also be advised by the prison psychologist, and the HSA have a psychologist which will have risk assessment done by him. And where there is a mental health issue, we will be getting advice from the psychiatrist from the HSA. The probation officers and the prison psychologists use internationally recognized risk assessment tests. So the board, although they're very experienced in their relative fields, and we have a person that's got a master's in criminology from Cambridge, we have, a very experienced board, but they will be making the decision based on the advice of the professionals.
The technocrats.
The technocrats, exactly.
Now, I know, before you go on, Peter, and I know normally we would want to steer away from controversy, but you mentioned the chairman earlier, and before we went on air, we talked about some of the criticism that was leveled, at some of the appointments. And again, for the benefit of our listening audience and to rebut that criticism that was out there in terms of the chair's past experience, can you again reiterate the background that the chairperson brings to this board?
Yes. The chairman was a senior official with a local bank, has now retired, but apart from that, spent a good number of years sitting on the bench as a lay magistrate when this person is also very active in the Justice of the Peace Association, was past president of the Justice of the Peace Association, so has a lot of experience in criminal justice. And just to reiterate the fact that the board makes the decision, but they are advised by professional technocrats, and I wouldn't want people to get the impression that we've got a group of amateurs making these decisions without proper advice. Precisely. So what's the difference between the two schemes? I sort of digressed a little bit there on the board. The difference, one of the major differences, is that at the present time, a prisoner can walk out of prison after 2/3 of their sentence. Okay, whether they're a risk to society, a risk to themselves, whether they've gone through any programs, they can come out. They can just walk out of prison. And we do know, as the police department will tell us, that certain crimes increase when certain people leave prison.
Yes.
Say they can walk out of prison at 2/3. They can also apply for the prior scheme. They could be released after 1/3 of their sentence or 50% of their sentence. The government decided that as risk and rehabilitation was their main focus, they wanted to have more time in prison, and so that programs could be used, and then once they leave prison after the 60% mark, then they would be on license to the remainder of their sentence. Okay, so that means that it's a 10-year sentence available for parole at 6. If they get parole, they will be under license for 4 years, and I'll talk about license conditions later.
Okay, folks, I want to remind you that you're listening to For the Record. I am your host, Dorit Connor, and my guest in the studio with me this morning is Mr. Peter Goff, who is the strategic advisor to the Deputy Governor, and we're discussing the conditional release law, the regulations, as well as the board's composition. Please stay tuned. For the Record, we'll be back shortly.
System 1 loaded.
1-800-534-8255. What is on your mind when it comes to the government, independence, and the opposition? Issues that matter to you. 1-800-534-8255. Waiting to hear from you. For the Record, with your host, Dorit Connor.
Good morning and welcome back to For the Record. I'm your host, Dorit Connor. My guest in the studio with me this morning, Mr. Peter Goff, strategic advisor to the Deputy Governor. We're expecting to have two other guests in the studio with us, and we're suspecting that they have been delayed by the earlier traffic delays this morning. We are discussing the conditional release law, which and regulations. They came into effect on the 15th of February 2016. Before we went to the commercial break, Mr. Goff we were discussing the difference between the old parole system and the new conditional release regime as well. So we will continue that discussion now, Mr. Peter Goff, and I'll hand over to you.
Okay. I was talking also about the new board. Mm-hmm. The new board were trained. We brought in a professional parole board member from the United Kingdom and also a lawyer from the United Kingdom that specialized in parole issues. And the new parole board were subject to 3 days training. This was paid for by the Governor's Office. So that training was very exhaustive. And then we've also trained local staff in the new law. The police, the probation service, the prison officers, the Department of Counselling. We had an internal session, and we will be training all the prison officers. We will be training all persons involved in the process, because it's very much a collaborative effort. All these agencies have to come together to be able to provide information to the new board. Mm-hmm. We will also be speaking to the Prisoners' Council. So we've already done I already did a session inside of Northwood to the Prisoners' Council, and we will do now it's law, and we will be publishing a pamphlet for the prisoners, so they will understand this is the pamphlet, Mr. Connor. This is a straightforward guide to the new regime. But let me first say that although the new law and regulations come in on the 15th, we will be it will only apply to the new prisoners that are sentenced after the February the 15th. It's not retrospective, so there'll be two regimes running at the same time. So all those that are sentenced prior to the 15th will continue under the old regime, and those sentenced after the 15th will be subject to the new regime. The only people that it will apply to that are currently in prison are the lifers.
Okay.
And I'll talk about lifers. It will also not apply to anyone that's sentenced to less than 12 months. They'll be dealt with in another way, and if Mr. Lavis will be able to explain to you the Rottle system. So if you look at the timing now, there will be extra resources required to support this law and regulations. But it's not going to be in this budget year. It will probably be in the 17-18 budget year, because a year will have to elapse before they can come up for conditional release.
Right. Okay.
the risk assessment I've touched on briefly, but the risk is the main focus of the board. They will not release anyone where there is a risk either to the prisoner reoffending. Also, if they think they're not capable of actually complying with the conditions, or if they're a risk to themselves. So it's as I said, it's a professionally assessed level of risk. So how do the prisoners benefit from this? Well, under the new regime, there will be a sentence plan. So as soon as the prisoner is sentenced and is committed to incarceration, there will be a sentence plan. What that plan does, it sets out what that prisoner should achieve to get out on parole, on conditional release, and it will also continue into the period when they're actually in society. And that plan will cover what programs they need to take, and these would be dependent on their on the crime. So there could be a requirement for them to take an anger management program. They could have, if they have an issue with alcohol or drugs, there could be programs that they have to take whilst in prison. If their crime is of a sexual nature, there are programs there for sexual offenders. So this will mean they'll get support in prison, and when they come out on conditional release, they will get some support in the community. And that support in the community is very important, not just for probation officers supporting them and monitoring them, but also for employers, because meaningful employment is one part of the rehabilitation process, family support, and community support. Because they will be coming out at some point in time, and we want to encourage prisoners to get parole, but they can only come out on parole when they are rehabilitated and are no risk. So if a person comes out on license, the license conditions will be set. These license conditions depend on the actual the crime, and
yes.
So there's no blanket set of conditions. Although there will be certain conditions that apply to all, and these are very straightforward. First of all, if you're on conditional release, you will not be allowed to travel outside the Cayman Islands for obvious reasons. Although you will be allowed to inter-island travel, but the probation officer will have to give their agreement so that they can pass you on to a probation officer in the BRAC to monitor you while you're in the BRAC. They will have to meet on a regular basis, their probation officer, who will set certain things which they have to do. They're going to have to agree where they're living, the premises they're living in. The other condition, which is for everyone, they have to engage in gainful employment. If they're not employed, they must register with the NWDA to look for work. And if there's any community service work, they will be encouraged to do community service work whilst they're on parole.
So question, Peter. For instance, the lifers that were released recently, they're not allowed to travel outside the jurisdiction of the Cayman Islands, as it stands.
That's
now?
correct. That's
okay.
correct. There obviously could be some extreme circumstances where that they may get permission, but there will be extreme circumstances where there may be an illness or a death or something like that. But that will be an extreme circumstance. So there are certain conditions on the license which every prisoner, when released, would have to comply to. But then there would be other conditions that are relevant to the crime. So there might be a curfew established. So from, say, they're not allowed to leave their premise from 10 at night till 6 in the morning. They must attend certain counselling sessions. They may be given random drug testing, alcohol testing. They may be subject to electronic tag, obviously. But what we want to make sure is that the conditions aren't too onerous. I know that sounds strange, but if we say you're not allowed within 50 yards of a licensed premise, every restaurant here has a bar.
Yes.
You know,
so it has to be practical at the end of the day. Yeah.
We want the prisoners, when they're out to have a family life.
Mm-hmm.
So if there's an anniversary or a birthday, they want to be able to join in that. They can't have a license condition that says you can't go near a bar. Now, there may be, if there is an alcohol problem, there may be certain exceptions to that, and the probation officer will be able to say that. But the bar may be within 50 yards of the church. So does that stop them going to church? Because so we have to be proportionate with the conditions that we set, so that we don't we want them to be monitored and controlled and what have you, but the control has to be reasonable.
Okay. Folks, I want to remind you that you're listening to For the Record. I am your host, Orrit Connor. My guest in the studio with me this morning, we have Mr. Peter Goff, who is the strategic advisor to the Deputy Governor, and we're talking about the conditional release law and regulations. For the Record is going to take a break at this point in time as we go to headline news. When we return, the conversation will continue. So please stay tuned. Don't change that dial. We know that we received one question in relation to the composition of the board, and we will be providing you with the list of the names of the members of the Conditional Release Board in the next segment as well. So please stay tuned. Good morning and welcome back to For the Record, where I have in the studio with me Mr. Peter Goff, who is the strategic advisor to the Deputy Governor. We're discussing the conditional release law and regulations, which came into effect on the 15th of February of this year. And of course, For the Record is brought to you by Caribbean Alliance Insurance Company Limited. Tomorrow is secured. You can call them at 949-9744 or visit them at Lister Towers. I also want to remind you that our phone lines are open. And if you have any questions, any observations in relation to our discussion, you can call us on our toll-free number, which is 1-800-534-8255. You can also call us on 949-8037 and the 949-6990. And, of course, you can email us at For the Record. That is one word, For the Record, at candw.ky. Mr. Goff mentioned the prisoner guide to conditional release, the pamphlet that has been produced by the government. And there is no doubt at the end of the day that at some point in time, the prisoners at Northwood, or Her Majesty's Prison Northwood, will know these guidelines better than the persons who produced them in the first place. And I'm not saying that in a derogatory sense as well, because it is the right of inmates to know their rights and to know what they expect of the law and what the law expects of them as well. So again, not saying it in a derogatory fashion at all, but they no doubt will be studying this and will be able to know and exercise their rights based on the law as well. So, Mr. Goff, I'll hand back over to you. I think you want to talk about lifers now?
Yes, exactly. There are three things I want to cover. First one is lifers. I also want to talk about the victim and the victim's family, how they're involved in the process. And I would also like to talk, possibly at the end, before we take calls, is how does human rights, or our Bill of Rights, affect the prisoner?
Yes.
Okay.
Yes.
So, the new law will allow prisoners that are sentenced to life, then there are 15 life prisons at the moment at Northwood. Within 24 months of this law coming into effect, which was, as you said, was the 15th of February, they can apply to the Grand Court to have a tariff set. What that means that it's not a retrial. A Grand Court judge will review the case and decide a minimum term of imprisonment. The the court will then, as I say, review the case and will specify a term. Now, the law has stated that for murder, the prisoner should serve at least 30 years before being considered for release. Not for release, but before being considered for release.
And prior to that, in the Cayman Islands, did life mean actual life?
It did indeed.
Yes.
Some of your listeners may remember that back in the 90s, there was there was a capital offence here, and you could be hung. I'm not sure of the details, but I understand the United Kingdom decided that through an order in council was to commit all those people that were
sentenced
to death to
life.
be to life. So with human rights, and I'll talk about human rights later, but there's been a lot of judgments and discussion at the European Court about, is life without hope of parole, is that unfair treatment? Is that inhumane treatment? So if we hadn't have done something in the Cayman Islands, we would have been imposed on us.
Yes.
So what government decided, that there will be a 30-year minimum, but obviously you can't bind the judge. So he or she has the discretion to increase that 30 years or reduce it. And I want to talk a little bit about what circumstances would the sentence be increased from 30 years, and what would be the reason for reducing it from 30 years. So let's start with the aggravating circumstances that the judge would take into account when he reviews the case of someone who's committed murder. First of all, the degree of planning or premeditation in the murder, whether the victim was particularly vulnerable because of, say, a child, say age or disability, the level of mental and physical suffering the victim endured or was inflicted on the victim before the death, if the person was in a position of trust, if the victim was murdered during a exercising public duty, or a policeman, or a prison officer, or an immigration officer, that will be taken into account and would be an aggravating circumstance. Where the murderer conceals the body, destroys the body, or dismembers the body, that will be an aggravating circumstance. Whether there are previous convictions, whether the murder took place as a result of abduction, or a sexual or sadistic conduct was involved in the murder. So those circumstances, if those aggravating circumstances were part of the murder, then the judge could increase it to 40, 50, or whatever. On the other side of the coin, the extenuating circumstances, where the judge could say, well, maybe this murder could be reduced from 30 to 25. These would be where there was an intention to cause bodily harm, but there was no intention to kill. Where there's a lack of premeditation, where the offender, the murderer, had some form of mental disorder or mental disability, which lowered the offender's degree of culpability. Also, whether the offender was provoked to commit the offence, where there was prolonged stress or whatever, and where the offender was actually involved in trying to defend himself or was in fear of violence, and a murder resulted from that. And also the age of the offender. If it was a juvenile, that may be an extenuating circumstance. And not all murder is the same, as you can see from those different circumstances. Mercy killing is one where the offender believes that by killing someone they're actually they're actually reducing their suffering or whatever, that does happen. So those are the things which the judge will take into account. So how will this all happen in terms of the transitional arrangements for those 15 lifers which I mentioned? Well, first of all, within 14 days of February the 15th, the prison director has to prepare a list of all the murderers and those that are life sentenced. He will send a list to the Director of Public Prosecutions and the Chief Justice.
Okay,
that's the first stage. Then the director will inform the prisoner that in writing that that their name has been submitted to the Chief Justice and the DPP, and then the Director of Prisons will explain what the process is. So the prisoner will have the right to be heard at the hearing, and just to say that you can't take into account whether the person has been a model prisoner or being rehabilitated. That's not the purpose of this exercise.
Okay.
It's to give a tariff as though they were sentencing for the first time. The prisoner will have the right to an attorney, and will able to apply for legal aid to be represented, and the prisoner would be informed of the date of their hearing. They'll prioritize those that have been in prison longer. Okay, that will be the priority. And once the date of the hearing is set, the Director of Public Prosecutions will get 3 months to serve a notice. And once that notice is served, the prisoner will get that notice and a submission from the DPP. And his lawyer will go through that submission, and then would, within 3 months, it's 28 days, sorry. Within 28 days, that the submission to the court, and then the Director of Public Prosecutions will give their submission to the defending lawyer.
Okay, Mr. Goff, if I could interrupt for a second. How does this relate to those lifers who are currently out?
Right, good question, yeah. Because as the public will realize, and if you picked up on, is that a number of prisoners have been released under the old law.
Right.
Yeah. So they will not be affected.
Okay.
But they will be, even those that are released will be monitored by the new board. And with life prisoners, the one difference is that if they're on license, that license will go on to the rest of their natural life. They will never come off of license. Okay. The license may change. As time passes, the license conditions may be less stringent, depending on how they comply with their license conditions. But they'll be on the license until they die, basically.
That's all lifers, or
all lifers?
All lifers.
All lifers, yeah.
Okay,
yeah.
And I'll just stick this question in there. How does that in itself jive with our Bill of Rights? Because at some point in time, a person would be considered to have paid their debt to society in terms, and at some point should be considered free.
How does that gel with our Bill of Rights? Well, as long as the conditions are proportionate and they're not overly stringent, and there will be a yearly review of all lifers by the Conditional Release Board, and as time goes on, it's likely that those conditions will be very, very limited, because it's a known fact that unless it's a sadistic killer, that murderers don't reoffend. And this is a huge step to change from life imprisonment with no hope for release to being released. And it was felt that there still needed to be some monitoring of, even though it may be a very light monitoring or slight monitoring, that there still need to be accountability back to a probation officer. So that's how lifers will be dealt with. I'd like, if I may, just talk a little bit about victims, how the victims will be part of the process.
Certainly.
Victims have been part of the process, the old process, but what we've done is to actually, in the law and regulations, we've established at what points the victim is involved in the process. So let me start off by saying the victim has the right to representation at all stages in the process. They can, but it's a voluntary thing. You can't. So if a person chooses not to be part of the process, that's fine. And it's the the Conditional Release Board want to take into account what the victim says, what the victim's feelings are. Mm-hmm. So as soon as the prisoner applies for conditional release, that's 6 months before the actual parole date. As soon as the person applies, then the Department of Community Rehab will contact the victim or the victim's family if they can be found. In some cases, they've left the island or whatever. But where they can be found, the department will contact them and invite the victim to make a written statement, or if they want to, a verbal statement for inclusion in a report that will go to the board. The victim can also ask to appear at the board. And normally what happens is we don't put the victim and the offender
face to face.
But the victim can appear in person, make a presentation to the board prior to the parole hearing. The victim is then made aware of the decision of the board. So if it's to release or to grant a license or not, the victim will be told. The victim will also be told what are the conditions of that license. So if a condition of the license is that the prisoner cannot enter into a certain area or contact a certain person, then the victim will know that they're not allowed to contact the victim or be in the neighborhood of the victim. So they'll be made aware of the license conditions. If there's a recall, if the person doesn't comply to the conditions, the victim will be told they're being recalled back to prison. And there is a whole process then in suspending the license and revoking the license. So the victim is involved in all stages of the process before the decision is made by the Conditional Release Board and during the monitoring of that.
Excellent, excellent. Folks, I want to remind you that you're listening to For the Record. I'm your host, Stuart Connor, and my guest in the studio with me this morning is Mr. Peter Goff, who is the Strategic Advisor to the Deputy Governor, and we're discussing the Conditional Release Law, which came, and regulations. They came into effect on the 15th of February of this year. We have one caller online. We're going to ask that caller if they can hold on for a few seconds while we take a commercial break, and as soon as we return from the commercial break, we will go straight to the phone lines. Please stay tuned. For the Record, we'll be back shortly. Good morning and welcome back to For the Record, where I have in the studio with me Mr. Peter Goff, who is the Strategic Advisor to the Deputy Governor. We're discussing the Conditional Release Law and Regulations. We have one caller on hold. Let's go straight to the phone lines. Caller, good morning. Welcome to For the Record. Caller, good morning. Welcome to For the Record.
Good morning, Mr. For the Record.
Good morning. Good morning, sir. How are you?
Oh, not bad. How are you? And good morning to Mr. Goff. Steve McField here.
Good morning, Mr. McField.
Mr. Goff, I believe that I'm subject to be corrected that in the UK, the legislation they have in the UK defines the kind of sentence, the kind of offense that would attract an indefinite sentence, and it also defines the tariff that goes with each one of those offenses if they have been committed. Some of those offenses do not have a release at all. But they range 12, 16 years, 20 years. Is our legislation similar?
No, it's not. The law, the conditional release law, establishes 30 years as the minimum to before conditional release can.
That is not in keeping with the UK legislation,
No,
and
it's not.
keeping with the cases that came out of the Privy Council from some jurisdictions about conditional release.
There was a case or cases, Mr. McField, where I think, and I'm not sure the names are correct, but where they appealed to the European Court that the sentence of life without the possibility of parole was considered torture and inhumane treatment. The European Court decided in the prisoner's favour, but that was then reversed for certain types of gratuitous murder. So the latest decision is that you can still sentence someone to life without the possibility of parole. But that was I think the Supreme Court came to that conclusion.
In the UK,
yes.
If you commit a murder, two or more people, and if there are sexual indications in the murder, and you use the firearms and so forth, there's no parole. And if you kill one person and so forth, and things like that, it goes down to 16 years.
Mm-hmm.
Depends on the kind of offense it was, and that is by legislation. It is not 30 years in the UK.
No, that's correct. That's correct.
And then I would just wanted to ask you, Mr. Orrit, you were talking earlier about the rights of prisoners. I wonder if I would like to get your opinion about the rights of prisoners to vote. Do you think that to take away their rights to vote because they're incarcerated is against the human rights law?
Yeah, and of course that is still a subject in the United Kingdom and the European courts as well. I think what we have done here in the Cayman Islands is if the person is on remand but not sentenced, and if they are registered, then provisions are made for them to be able to cast their vote if they're registered and if they're on remand. But if they're sentenced, then they're not able to.
Yeah, because I think we mix up prisoners and accused persons.
Mm-hmm.
And accused persons is a person who has not been convicted and therefore hasn't lost any rights.
Right.
And according to our law.
Yes.
Prisoner is a one who has committed some offense and has been sentenced by a court or law. But I wonder if the sentence itself for the offense would take away his right to his democratic right to cast a vote for the person who represents him.
Mm-hmm.
Is that part of the penalty too? Is he penalized for not voting for the person who represents him in his constituency?
So are we talking about a person now who's out on conditional release?
No, a person who's been convicted of an offense.
Oh, okay. I guess it, Mr. Markfield, it depends on when what you consider. If that person has lost all liberties, does that liberty include the right to vote? And some people may argue that it does.
Yes, and some people argue it doesn't.
That it doesn't. Yeah.
It doesn't.
Yeah, and
because what he's sentenced for is the offense that he committed.
Mm-hmm, mm-hmm.
But he doesn't lose his liberty to vote for his representative.
Right. Yeah, and to have such representation and to make that choice of such representation.
Exactly.
Yeah.
Exactly.
Yeah.
So perhaps you could have a debate on that sometime soon. Since they're considering that, since that's in part of the UK. And of course, you know where the UK is leading to now. Yeah, they're now being convinced. At least a majority of the people in the UK are saying that they have lost their sovereignty. their parliament is not supreme anymore, and their court is not supreme anymore because everything is they're overshadowed by Brussels, and they're the same position that we find ourselves because we have never had any supremacy because we were a colony under Jamaica, and then we became a colony under United Kingdom. So there's this debate going on in the UK and in Europe and in Scotland also. So perhaps maybe one day, Mr. Orrit, you could have a debate on the rights of prisoners and the rights of other people.
Certainly, yeah. And we can look for you to lead that as well. And if we can involve the government side of things on that would be good. While we're on the subject and not wanting to detract from what we're discussing, but last week I think there was another judgment by the Supreme Court in the UK in relation to criminal enterprise.
Yes.
And they have pointed out that will may affect the overseas territories as well, because many of us have fashioned our legislation similar to what the UK has, and that court decision, that Supreme Court decision, had some implications for that as well. So that is something else that we may want to discuss also. Yes.
Let me tell you, I got into trouble in law school over many things, but that case was one of the things I got into trouble with one of my professors, and he didn't give me good marks for that, because I always thought, there's a case, I can't remember the name of it right now. There's a case that set the stage for that, where 2 or 3 guys went to rob a place, and one guy said to the other, "Let him have it, Robbie," and the other guy, and that guy shot the proprietor of the place, but the other guy didn't even know that the other two were one of the guys were armed and had not taken any part in the conversation regarding the shooting, and the court held that they were all jointly responsible for the murder because there was a joint enterprise. And I always maintain, how can you if you were talking about intent to commit an offense and the actus reus and the intent, how can you say that one person, all 3 were guilty, when the other person had no intent to commit the murder and did not even know that the other person was armed with a firearm and stuff? And I got lots of problems for that because they say, well, if you don't write that in your exam, you're going to fail. And I always thought about that. And finally, the court come around to the fact that you can't blame one joint proprietor, one joint accused when the other person has committed a murder, and that person usually didn't know about it.
Didn't know that the person intended to actually, commit the murder. Yes, the sufficiency. Yes.
So yeah. I'm happy about that. I'm happy about that decision, and I hope that, and you know what case comes to mind here? The Roper Manderson case.
Mm-hmm. Yes.
Where the evidence was that Manderson was supposed to have committed the murder, and Roper was an accomplice because Roper was in a cell with him. So I think that case should be looked after in the light of what the High Court now said in England.
Yeah. I want to thank you very much, Mr. Macfield, and look forward to further discussions with you during the course of the week as well.
Thank you very much.
Folks, I want to remind you that you're listening to For the Record. I'm your host, Stuart Connor, and my guest in the studio with me this morning is Mr. Peter Goff, who's the strategic advisor to the Deputy Governor, and we're discussing the conditional release law and regulation. Please stay tuned. We're going to take a commercial break. When we come back from that break, we will have another guest in the studio who will join us. So please stay tuned. We'll be back shortly. Good morning and welcome back to For the Record. I have in the studio with me Mr. Peter Goff, who is the strategic advisor to the Deputy Governor, and Ms. Deborah Prendergast, the administrator to the Conditional Release Board, has joined us also. We believe that Mr. Lavis may be still caught in traffic because of we're advised that there was an accident earlier this morning, and as a result of that, traffic is still backed up. But if Mr. Lavis is listening, he can certainly call in on our numbers. You can call in our toll-free number, which is 1-800-534-8255. That is probably the best one. It means no cost to him. And he can also join us in the conversation by calling us there, and we can link him in with our two panelists that we have in the studio as well. So, Ms. Prendergast, good morning and welcome to For the Record. I believe this is your first time on the show.
Yes, it is. Good morning.
Good morning. I'm sure that Mr. Goff at some point in time is going to hand over to you because he's been doing all of the talking so far. But I believe before we went any further, we wanted to talk about the composition of the Conditional Release Board. And we know that the members of the board really want to keep a low profile because they're there to do work, not necessarily to publicize or to be publicized. But also, those names were published in the Gazette, and the Gazette is also a public document. So there is nothing wrong with us advising our listening audience as to the composition of that board.
Yes. Okay. Yes. The chairman is Mrs. Deborah Humphreys, an ex-banker, and was also a president of the Justice of Peace Association, and was also a magistrate. We have as vice chairman Mr. Richard DeLacy, who is a Queen's Counsel. We have a Mr. Nicholas Dunn, who is a lawyer, and we have Susan Bodden, who is a psychologist. We have Danielle Coleman, who is in charge of the Cayman Hospice, and we have as a pastor Mr. Godfrey Magoo. We also have another lawyer, Timothy Derrick. We have a lady, Alicia Latoya Folks, and we have a Mr. Alan Brady, who is in HR. So those are the board members, a different balance than the previous board. Obviously now the decisions that they're going to make are not recommendations, so their decisions can be challenged at judicial review. Mm-hmm. So it's very important that we have, it is a quasi-judicial board. We have to make sure that the decisions we make in the board are lawful. Mm-hmm. And that, yes, you can still challenge, but we feel that with the expertise we have on the board, that we're less likely to get challenges. And as I said earlier, they have been now trained by the UK. The decisions that that the board make can be challenged. Not only can the board be challenged on the basis of not releasing someone, they can also be challenged on the basis of recalling a prisoner when their license is suspended or revoked. I talked a little bit before the break about the life prisoners. Once they've all gone before a judge of the Grand Court and the tariff is set, they can, if they don't agree with it, the prisoner can go through the normal appeals process. Obviously, the decision of the Grand Court will be appealed to the Court of Appeal and on app. So, in this particular scenario, we've got to make sure that there is like a fair trial. And talk a little bit about the human rights implications of the new law. There are two aspects to the Bill of Rights as it applies to conditional release. One is the rights and freedoms of prisoners that are affected by the decisions, and the other is the duties of the public officers in recommending courses of action and the parole board making decisions. So, start with the first set. Obviously, prisoners, when they're in prison and when they're on parole, have certain rights. So I mentioned earlier about imposing unreasonable conditions on the prisoner. Mm-hmm, mm-hmm. So if we bar every prisoner from that's on release from going within 50 feet or 50 yards of a bar, then we will be affecting that person's family and private life, which is Section 9 of our Bill of Rights. If we restrict movement that is not proportionate to the particular person, then that will affect Section 13 of our Bill of Rights. Again, it has to be proportionate and reasonable. Obviously, we can put limitations on a person's freedom, but we want to make sure that when we set the condition, it's not too onerous and stops them actually going. For example, if we set a curfew of 10 p.m. to 6 a.m., and the person gets a job in construction, they may have to leave at 5 o'clock in the morning. And we see from the traffic this morning to get to work at 7 o'clock, you may have to leave before. So we want to make sure that we don't artificially restrict movement. Fair trial, Section 7 of our Bill of Rights. One reason why the board is making the decision rather than the governor is that this board is independent of the executive arm of government or the legislative arm of government. So fair trial says it should be an independent trial. We should also make sure that we act within certain timeframes. The law and regulations set out now exactly what the time frame is for a person getting to a conditional release meeting, a prisoner getting a conditional meeting. So 6 months prior, the process will start prior to the date of possible release, and every agency will have to comply to a certain timescale. So that ensures that these preparations for the release are not elongated and are not that we need to operate in an efficient and effective manner. The non-discrimination clause, Section 16, and it sets out exactly in that Section 16 of the Bill of Rights that we can't discriminate on the basis of race, nationality, or whatever. So that's the first part of rights and freedoms of the prisoners. I know we had a caller recently, Mr. McField, who talked about rights of prisoners to vote. That's a whole different argument, which I won't attempt to talk about this morning. But the other part of it is that responsibility of public officers. I think people, when they look at the Constitution, they just see rights and freedoms, but it's rights and freedoms as well
as responsibilities. Yes.
So the responsibilities that we as public officers have is to make sure that all the decisions that we make as public officials must be lawful. So all the decisions in terms of timings and what have to be in compliance with our law and our regulations. The decisions we make have to be rational and proportionate. So we're making judgments, yes, but we want to make sure that they are proportionate. And there has to be procedurally fair. So the processes that has been designed in the regulations ensure that the prisoner coming up for parole gets sight of every document that's prepared to support or not his case for being released. There's one exception where there's security or is involved, but all documents that the administrator will collate from the various agencies will be presented to the prisoner in an interview, and the prisoner will then have to sign off to say, yes, I agree with this information. Okay, so it's very important that we need to be procedurally fair in all our policies. And this is nothing new. This happens now. It's not something that we've been shy of in the past. We've always been carrying on in this manner. But what the law and regulations set out is a procedure, a timeline, and that's new to this to the regime. So that's the human rights aspect of the conditional release. One thing I haven't talked about is the recall prisoners. Hopefully, once the license conditions are set, we're hoping that all our prisons that are released will comply with their license, but that's not always the case. And there is now a procedure laid down. There was a procedure before, but the procedure is now laid down in the law. And essentially, once the prisoner, the conditional release board say, yes, we can release this person. He's no longer a risk to society. He's no longer a risk to himself. We believe that he can comply with the conditions of license. Once that happens, the prisoner will be issued with a license which they have to sign to say that they will comply with this license. Mm-hmm. Now, the license could include electronic tagging. At the moment, no parole prisoners are electronically tagged, only bail prisoners are. Okay. Now, we're hoping that we won't have to use electronic tagging in many cases. Because there's obviously going to be an element of trust. If you have to put an electronic tag and you have to put 20 conditions on the license, you have to start to wonder.
Yes, that tells you something right away.
Tells you something right away. We don't want to set the prisoners up to fail. And there was a time when part of the license conditions was to attend church. Well, that's no longer a license condition. So we want to make sure that the license conditions, which the prisoner agrees with, are, again, I want to use the word again, proportionate and reasonable. And it's not one size fits all. It's designed for each individual prisoner.
Mm-hmm. If we could for a minute,
yep.
Peter, can we discuss these conditions that are placed on a license?
Yeah.
What is being done to assist the prisoner who's going to be released unlicensed to transition into society? We have challenges, for instance, like obtaining a driver's license. You may have some prisoners on release who are over the age of 60, 65, but need to still continue to work, to earn a living, because they may not have any other financial resources. And I'm not sure how much is provided to them by government during the course of their release to get themselves, on a solid footing,
yes.
As well. So some of the challenges that they're going to face to ensure that there is a high measure of possible success in this release program. What do we do to assist these prisoners who are on release?
I think this would be a great opportunity to include Deborah in the discussion.
Yeah, certainly.
Oh, okay. This is where the probation officer would come in. The supervision aspect of it this is where the assistance of the Department of Community Rehabilitation and their supervision of the parolee, they would assist them in this respect. Also, in preparation for the prisoner to be released, the prison does a lot in assisting them and preparing them for their eventual release. So there's a program that exists in the prison that's called temporary release. It's called ROTEL for short. So that is a program that actually runs. It has nothing really to do with the conditional release aspect, but it also prepares prisoners who are, say, on the probably 2 years prior to being released. They may qualify for this program, which allows them to go into the community, probably to be released on a temporary license daily, to go out to work or to probably visit family members. So I know if Mr. Lavis is going to be in studio, I'm not quite sure if he's going to be here, but he would be able to probably elaborate on this a little more. But that program also exists within the prison, and also the probation officer normally does a lot to assist prisoners once they're released and helping them transition back into the community. So they normally would connect them with the Department of the National Workforce Development Agency. That's part of their license. So normally, that's their part of their license conditions.
Okay.
So you have to sign up with that department if you're not already in contact with somebody that has a job for you to provide assistance on the outside. You have to sign up with that department once you're released. So that's normally part of one of your conditions on your license also. So the normal agencies that are out there, you'll be connected with those with the assistance of the Department of Community Rehabilitation. So that's normally their function, to connect you in transitioning back into the community. This is something that has always been in place. It's nothing new. It's just that we are now formally putting this in writing and saying we have a formal law or formal regulations, but it's always been in place. It's something that we've always done.
Okay.
Normally.
Now, while you have the mic, can you tell us about your role as the administrator to the Conditional Release Board?
Well, my role is just basically to make sure that all of these things are in place, that all of the documentation, everything is in place for the preparation of the meetings. We were normally at quarterly meetings in the past. Now we're moving to monthly meetings, so it's going to be a much faster turnover. So we have to make sure that all these timelines that are put in place now are complied with. So it's going to be a little bit faster for us to move. So the agencies now have to ensure that those reports are all ready, all of the necessary documentation that we have to have those online. So we are working with computer services. Hopefully we'll have all this online.
Yeah.
We're preparing for our first meeting in March, where we used to have normally probably 8 persons a quarter, or probably 8 to 10 people. We'd normally separate those meetings into 2 meetings. What we're moving to now is monthly meetings. So if we're having monthly meetings, we'd probably be breaking down those into maybe 2 or 3 persons a month. So hopefully the rate of turnover now will be having 2 persons a month. I guess we should be able to comply with having these timelines in place. So,
yeah, if I could just add that,
sure, Peter.
We're moving into the electronic age. There used to be huge files which Debbie used to have to carry around. Now every conditional release board member will have an iPad, and all the information will be stored in that for them, so they can read the documents from that. The issue, which I don't want to focus on too much, but I think I really ought to talk about non-compliance with a license.
Yes.
This is something where if there is a non-compliance, either the police or the electronic monitoring centre will actually inform the probation officer that the person is out after curfew, or they've been arrested for another offence, or whatever. They then would provide a non-compliance report to the board, and the board then have to decide whether the extent of the breach of the conditions are significant enough to recall that person into prison. If, for example, if they're a few minutes over their curfew, that's not really a significant breach of the license. So that order, that conditional, the compliance report will go back to the board. The board will then make a decision. If they decide it is a significant breach, the person will be immediately arrested and returned to prison. We return the person to prison as a remand prisoner. Okay, at that point, the license will be suspended, and the prisoner will be given a copy of the breach report, a non-compliance report, and they get a chance to study that and to appeal to the board whether they should continue on license, or whether the license should go from a suspension to a revocation.
But that appeal will take place while they are back as a remand prisoner.
Exactly. Yes, exactly. So there are tight timescales so that the prisoner can appeal in person to the board, and can have a representative, so that the board may decide, well, yes, there were good reasons. And for the breach, and they may continue the license and release the prisoner, maybe change the conditions slightly. Or they may say, no, this is a substantial breach, and that person should come back to prison as a convicted prisoner rather than a remand prisoner. So we're hoping that we're not going to get too many of those, and we haven't had many of those in the past. I think 2 or 3 over the last.
For the last year, we've had like 2 recalls.
Two recalls. So generally, prisoners that go out on parole in the past and on conditional release in the future comply to their conditions because they want to stay out of prison, and we want to encourage them to stay out of prison. We want to encourage them to accept parole as a means of rehabilitating themselves in society.
Now, I'm sure that some members of our listening audience would ask the question: these changes, this new board does not come without some costs to government, and how are those costs being absorbed? Where's the money coming from to fund all of this?
Right. There will be a cost, yes, a short-term cost. There will be a requirement to have people on license longer, so there will be need more monitoring, and the DCR will need extra resources to do that. The programs which we need to implement in the prison to ensure that they comply to their sentence plans will cost money. The costs of the implementation are not going to be in this budget year. If a person is sentenced to a year after the 15th of February this year, it means that they're only going to become up for conditional release after March, April next year. So we don't have, we're talking about approximately 4 prisoners a month at the moment for approximately 4. So those people will be on license longer. But we have to, the government have committed resources for this conditional release law. It's a very important law. It's a major change in our criminal justice system, and they are committed to providing the resources for this. But you also have to look on the other side of where the savings are going to come from. Eventually, and this is not going to happen overnight, but eventually the prison population will reduce, saving money there. The cost of people going back to court will save money in court time, will save money in police time, arresting and charging, will save money in our DPP for prosecuting. So in the long term, there will be savings. But what is more important than the financial savings, in my mind, is that we're going to have a safer society, a safer community. And can you put a dollar figure on that? We've seen where other countries have got higher crime rates than us. How does that figure in terms of tourism, investment? We've got to look at the big picture, and we've got to look at it strategically in the long term, not just think about, well, what extra this is going to cost. Because I believe that in the future, we will have a safer country and we will reduce costs. But as I said, this is not an overnight success.
Okay. Now, Peter, again, you pointed out earlier that the law is not retroactive.
Exactly.
So that any person, it only applies to prisoners sentenced after the 15th of February and to prisoners currently serving life sentence. Can you tell us the reason for that? And is there the likelihood of any challenges in terms of those prisoners who feel that they're being treated unfairly? That we've created two classes.
Yeah, exactly. Well, it's a very good reason why it doesn't apply retrospectively. I think there will be a riot in the prison if the prisoners that were expecting one thing and then all of a sudden the law changes and they have to stay in prison longer and they have to be on license longer. Yeah. So yes, there will be 2 classes of prisoner, those before and after, but that's quite usual in many societies where I think Mr. Lavis had told me that in the UK, the parole rules had changed so many times that they were running 3 or 4 systems at the same time.
Wow.
So it's not unusual. But the very reason we did it is to avoid people being discriminated against because a new law has come into play. That was the basic reason. And it's unfair. It's unfair if somebody has been sentenced and they realise that they will come out in 2/3 without a licence, and now they have to apply for parole and be on licence for the remainder of their sentence. That would probably be more of a human rights issue than the 2 classes of prisoners that we now have.
Got you. Okay. Folks, I want to remind you that you're listening For the Record. I am your host, Orrit Connor, and my guest in the studio with me this morning, we have Ms. Deborah Prendergast, who's the administrator to the Conditional Release Board, and we also have with us Mr. Peter Goff, who's the strategic advisor to the Deputy Governor's Office, and we're discussing the Conditional Release Law and Regulations. Please stay tuned, taking a commercial break. After that commercial break, the conversation will continue. Good morning and welcome back to For the Record. I'm your host, Orrit Connor. My guest in the studio with me this morning, Ms. Deborah Prendergast, the administrator to the Conditional Release Board, and Mr. Peter Goff, the strategic advisor to the Deputy Governor, and we're discussing the Conditional Release Law and Regulations. I just want to remind you we're on our last 15 minutes. If you have any questions, any observations, please feel free to call us on our toll-free number, 1-800-534-8255, or 949-8037 or 949-6990, or email us at fortherecord. That is one word, fortherecord, at candw.ky. Mr. Goff, I'll hand straight over to you.
Yeah, I want to clarify one issue that we touched on briefly before, and that is the lifers. We have we had a mechanism in the prison law for the governor to release lifers, and 6 prisoners applied for that under the old prison law. So those 6 would they won't be affected by this law, only to the tune that the new Conditional Release Board will monitor them. We have released 5 lifers locally, and we have released a further 1 person who was immediately deported. He was not a Cayman national. Mm-hmm. So we've six have been released, and we have 15 at the moment that will be going through the process I talked about earlier.
Yes.
Okay.
Okay. We had one question from one of our listeners as well. It says, if I could please ask my guest, why is there an appeal to the same board who made the adverse decision against the prisoner? Why no appeal process to a higher tribunal?
Okay. There is an appeal to not a higher tribunal, but to appeal to the court in terms of a judicial review. So there are 3 basic decisions that the board is making. One is whether to release on conditional release. That decision can be appealed against to a higher court. Then there's the decision to release with conditions, and the conditions have to be agreed by the prisoner. If a prison doesn't agree with having a curfew or having random drug testing, to be brutally honest, the board will not release them, because that will be a condition of the release. The prisoner is still a prisoner, whether they're incarcerated or whether they're in society. They still are classified as a prisoner.
Okay. If I can interject for a minute. For instance, if you had a condition about drug testing,
yes, but
that prisoner was not convicted of a drug offense and there was no evidence of any drug usage at all, could that conditional not be considered to be unreasonable in the first instance?
Exactly. So one thing that during the training of the new parole board, which the UK specialists emphasised, was the condition has to be relevant to the crime.
Right.
And we talked about the bar issue, and the same applies to the drug issue. If there's no history of drug taking, then that wouldn't be a condition. Or if there was no history of violence, then they wouldn't go to an anger management course. So it has to be specific. We can't have a one-size-fits-all, because that's when we will get into trouble from a human rights perspective. Do you want to add anything to that, Debbie?
No, I was just going back to the discussion we had a little bit earlier in terms of the life prisoners and the transitional clause. We currently have 2 other life prisoners that are in the process. One was considered by the old parole board, the former parole board, and that application would still currently go to the governor for her consideration. If there's a review in that instance, then that would now go before the new conditional release board. But it would not, the decision for that would not be with the conditional release board. That would be referred back to the governor for her decision.
Okay.
There's also a new application, and that would also go to the new conditional release board for their recommendation. But as it states in the law, the final decision for that, as in the transitional clause, would go to the governor herself.
And that transitional clause is there for those who find themselves in limbo between the old and the new.
Yes, that's just for in the cases of life prisoners.
Yes.
Yes.
I think it would be remiss of me if I didn't mention the sterling work that the existing parole board have done over many years. This is not a high-profile board in terms of you get a lot of accolades for doing this job. They have to make important decisions, and they have to consider every case on its merits. There's a huge amount of reading of reports, interviewing prisoners, and making judgments. And they've just done a sterling job, and I'd like to thank them personally for the work that they've done. Not only the work that they've done as a committee, as a parole board, but also how they've helped frame the new law and regulations. There was a committee set up to once I'd written the policy paper, we had to turn that policy into a law and regulations. So they were very generous with their time in sitting at committees, and Mr. Connor, the hours you have to spend when you're drafting legislation. Every word has to be questioned. Well, what do you mean by this?
Yes.
If you do that, what's the consequence further down the line? So it's a very laborious, sometimes tedious process. But the old parole board gave of their time unstintingly to help us frame these new regulations. So I just want to record my thanks to them and all the people that were involved in the process, from the human rights lawyers for government, for the drafters, for DCR, for the police, the courts. It's because this conditional release, as was with parole in the past, requires so many people to be involved to come up with the advice to the board, from HSA mental health, from HSA psychologists, from the prison. It's a real collaborative team effort, and I'm so proud of the people that actually gave of their time and wanted to make change, wanted to see a difference, and try and stop this revolving door process which happens with our people. In 1 minute, out the next, back in. It's such a waste of life. And when we visited the prison on Friday, particularly the young people that have just wasted the opportunity, the potential that they had, because they made a mistake. And you make mistakes when you're young. We all made mistakes.
Yes.
And fortunately, it didn't result us getting locked up. But we've got to be able to try and put resources into making sure that those people, when they come out, that can actually live and contribute to society. So we've also got to the Conditional Release Board have got to visit the Bridge Foundation, the halfway house up in West Bay.
Mm-hmm.
We're going to look at that as a possibility of as a next step into the reintegration in society. We're also going to be looking at Caribbean Haven up at Breakers, so that the parole board will the Conditional Release Board. I still can't get that. The Conditional Release Board. It's a bit more of a mouthful than parole. The Conditional Release Board will actually see where they're going to be recommended people to go and the programs that they operate. So that's just as important to know what other agencies are going to help. I think we're coming up to the end of time now. Just if I could make some concluding remarks.
Yeah, we have about 7 minutes left.
Okay. Well, is there any other questions, or are there any callers?
No, we have no one on the phone line,
Okay.
so certainly an opportunity for you to cover all the points that you want to cover and to wrap up.
Yeah. Okay. So, if we look at what outcomes we want to achieve, right? There's one thing of putting a law in place and regulations in place, but we have to be clear about what we want to achieve with that law and regulations. And when I opened up this morning, I talked about the statistics, the prison population compared to the world population, our reoffending rate compared to the rest of our Caribbean neighbours. So if we could just focus on three things, the three objectives that the board wants to achieve. They want to rehabilitate prisoners so they can function in society and live a useful life. We want to make sure in achieving that outcome that we protect society. And that's, if we bring it all down to one thing, it's about assessment of risk. You can't eliminate or mitigate totally the risk, but you can make sure that with the proper assessments and with the proper information, the board can make decisions that will reduce the repeat offender. So that's the second objective. The third objective, and we all know the costs of producing or keeping people incarcerated. I don't know what the latest figure, the figures banded about are 60,000 a year.
It's certainly much more costly than having them out if
Exactly.
we can rehabilitate them. Yes.
Exactly. So if we can reduce the cost of incarceration and maybe divert some of that money to identifying children, young people at risk, so that they don't end up in Northwood. So if we take half of that and focus that on children, which we know and are identified through a proper analysis. I think the last figure I heard from Michael Miles, who is really the champion of this this initiative, there are over 250, I think, 250 children at risk in our primary schools. So if we can focus some of that money that we save on preventing or trying to prevent those people getting into trouble and to end up in Northwood, that will be money well spent. Deborah, do you have anything you want to say in terms of summing up?
Well, I guess it's just that the only difficulty I see is just, basically transitioning for myself. It's just being able to resolve the transition between moving from quarterly meetings to now monthly meetings. So it's just, it's going to be a lot faster for myself. And then, it's just getting used to a new board. And change is something. It's good. It's challenging. But hopefully I'm seeing a lot of progress with us moving forward now with the agencies, with everybody coming on board with this new conditional, release regulations now coming in place. I think before when it was just an idea and it was just a vision, everybody was a little bit taken aback and perturbed and saying, well, I don't know how it's going to work and if it's going to all come together. But I guess now that, we're seeing it actually come to fruition, I think everybody's kind of getting on board now, and it will. And I guess in a few months we'll look back and say, I guess, we just sort of pulled it together. So hopefully we'll get there.
Yeah, I'm sure. And Mr. Goff, you mentioned earlier the hard work that was put in by the former members of the parole board and others. And it's important to point out to the public that almost all of them, it's on a volunteer basis. They may get a small stipend from government in terms of travel and stuff like that, but they give of their time. Their employers allow them to give, of their work time as well, even though whatever work that they have to do, in their workplace, they still have to go back and do that at some point in time. But certainly the work that they do is on a volunteer basis. And we saw something new within government as well, where the governor's office actually put out a request for people to come forward to apply to be a part of this board as well. Which we get people complaining about who comprises boards, but at the same time, people get an opportunity to put their names forward, put their credentials forward, and say, "Here I am. I'm willing to serve," and they know exactly what the conditions of service are.
Yes, I think this was a great innovation to advertise the position, and the governor's office worked very hard in making sure that there was a balance on the board. You don't want all lawyers; you want a balance, and although there are more lawyers than anything else on the board, at least we have a balance in terms of we have the psychologists, we have the pastor who bring a different dimension to the board, and I believe the governor's office did a good job in selecting this board, and say that 20 odd people applied, and they went through an interview process. There was due diligence done, as you would normally. And yes, they do get a small stipend for attending a meeting, but it has no reflection on the amount of work they have to do. Yeah. Some of these files, 30, 40 pages long on one prisoner that they have to read. You think more, Debbie?
It's a lot more than that.
Okay.
Yes.
I don't read them, so.
I used to have binders that were that thick.
Yeah.
It's a whole tree.
Yeah. So the work they have to put in reviewing all these files, plus the time they have to spend in terms of the hearing, it's a lot of work. It's a lot of work, and I'm thankful of the people that are now on the new board, as I was thankful of the people that did that work previously. I think finally, I'd like to say that I'd like to thank the Premier for his support in this new regime. I'd like to thank the Deputy Governor, who has supported me in this quite long process. I believe that the first report was done by Michael Bradley. Remember Michael Bradley?
Yes.
The first report recommending conditional release was done by Michael Bradley in 1999. So it's taken a long time. But I think we've got a really good law and regulations, and I think in the future we'll reap the benefits of that. But I want to just reiterate, it's not going to change overnight. It'll take time.
It certainly will. Okay. And the success of the program will rely equally or depend equally on the recipients of the conditional release, as well as the general public, in terms of how they receive them, how they interact with them, as well, and not necessarily ostracize them from society as well. Yeah.
Very, very good point. We all have to support the prisoner coming out and reintegrating society, from employers, from family, because we don't want them to return to prison.
Right. Yep. Folks, I want to remind you that you've been listening to For the Record. I want to thank Mr. Goff and Ms. Prendergast for being here with us this morning. We hope that you've gotten a clear understanding of the conditional release law and the regulations, and we encourage you to do your part in terms of assisting those who we're attempting to reintegrate into our society and to be productive members of our society as well. I want to thank our sponsors, and For the Record was brought to you by Caribbean Alliance Insurance Company Limited. Their motto, tomorrow secured, and you can call them at 949-9744 or visit them in Alista Towers. I want to remind all of us that we are our brothers and our sisters' keepers. There is always someone out there who's less fortunate than we are, and I ask you to extend a helping hand to them. If you can't do that, then I suggest you donate to a worthy charity. We always want to consider those who need, not necessarily those who want. I say to you, have a great day. Continue to listen to Radio Cayman, your radio station. Join Sterling Dwayne Abanks at 12 noon for Talk Today. Have a great day, and may God continue to bless these 3 Cayman Islands.
Informative, impartial, insightful.
This is your talk show.
1-800-534-8255. Your calls, your input. This is For the Record.